Namaste, good morning. Let us start with episode number 179 of AAA Weekly Webinar Series. IBC Amendment Bill 2025 has actually been in talk. This is our fifth episode on IBC Amendment Bill 2025. However, this particular episode is dedicated to a new framework, a new era, which is debtor in possession era. Although it was earlier also introduced as pre-packaged insolvency resolution process, but that could not take off because of various apprehensions from the creditors. And that was also applicable only to MSME. However, this framework, as creditors-initiated insolvency resolution process, in short, we will call it as CIIRP. We have already seen CIRP. We have already seen pre-packaged insolvency resolution process, which is PPIRP. And now we have also seen personal insolvency resolution process, which is PIRP. Now we are going to see creditors initiated insolvency resolution process, which is CIIRP. In this entire episode and also in future, we will refer this term as CIIRP. So this is again a new era which in fact was wanted by the creditors since long. This is the era which is also most popular in America and in UK and in other developed countries. Creditors in possession is not something which is popular internationally. Debtor in possession is popular internationally. However, the debtor in possession has to be discreet. It has to be a very, very silent effort. Without going to any court, without going to NCLT, this debtor in possession framework can be started. Today, we would only be deliberating on this new framework, which is CIIRP. So this is where we start our journey today. And I believe we would be discussing the various scope, eligibility. This is a new chapter has been provided in the proposed in the amendment bill. That chapter name is 4A. In this chapter, and this also will become popular, that this company has gone into chapter 4A. Like in America, we say that this company has gone into chapter 11 or chapter 10. So that also would be a kind of terminology which will be used in future. Either it will be called as CIIRP or it will be called as chapter 4A. So we will also see what kind of role of a resolution professional is in this framework, in this chapter, and we will also see what kind of outcomes are possible in this framework, in this chapter 4A. I believe in future, this will become popular as chapter 4A. Now, let us understand this chapter 4A starting. This is as per the one part of the Amendment Bill 2025, and it is basically based on various feedbacks, various deficiencies of pre-packaged insolvency resolution process, which has been communicated to the lawmakers by bankers, by resolution professionals, by lawyers. This has been communicated. The reasons for not picking up the choice of PPIRP actually has led to this CIIRP. And there are various difficulties which actually was given as a feedback to the lawmakers has been cured in this CIIRP. This offers, in fact, this process or this framework offers an alternative pathway for financial creditors to address insolvency situations efficiently. The new section 58A to section 58K are inserted in the amendment bill, and this actually is basically for shaping the future of the insolvency resolution in India. First question comes is who are the corporate debtor who would be eligible for this? Who are the corporate debtors who would be eligible for this? So this is something which will have to be notified. The lawmakers, the government has kept it open for the time being. One, they would decide about what kind of amount of asset, what kind of amount of income, or even a combination of income or asset that in fact would be notified by central government to see these are the companies who have this much of asset, this much of income, or a combination of these two would be the eligible corporate debtors for action to be taken under CIIRP. Another is the also it has to be seen that the particular corporate debtor should have a class of creditors or a class of financial institutions. In case a particular creditor, in case a particular corporate debtor has all that asset, has all this income as notified, but that particular corporate debtor doesn't have those class of creditors as may be notified by the central government from time to time. And also, if the particular corporate debtor has a kind of amount of debt, which can be initially, it can be said, okay, let us understand that any company which has a total amount of debt of about 500 crores from financial institutions or from financial creditors, that would only be eligible for this framework. So first condition, assets and income or a combination of two. Second condition, that the corporate debtor should have financial creditors who are a class of creditors as notified. Third, it can also be restricted to an amount of debt. If a company has more than 10,000 crores of debt, that probably may be kept out for the time being, and it may be experimented on companies which has lower amount of debt. So this is various also such other categories of the corporate debtor as may be notified. So the government can notify all these categories: income, asset, a combination, or a class of creditors, or the amount of debt, or any kind of category of the corporate debtor. So this has to be notified by the central government, and to be notified by way of a notification where the government will declare the amount of asset, etc. This is awaited. So this is one is the eligibility. Then even if there are eligibility, even if the corporate debtor match with the asset, income, class of creditors, amount of debt, and any other condition, even if it all matches, but the corporate debtors who would not be eligible for CIRP would be any corporate debtor who actually is already undergoing a CIRP or PPIRP. Any corporate debtor who is undergoing a liquidation process, any corporate debtor which has actually undergone or has completed the CIIRP, in fact, within 3 years preceding the commencement of CIIRP. Any corporate debtor which has already completed PPIRP within 3 years, CIIRP cannot be commenced. Similarly, any corporate debtor which has in fact completed CIRP and CIIRP cannot be initiated for the next 3 years. Now coming to the second most important part of this framework, where the government has to notify, first of all, who are the financial institutions, who are the financial creditors who can initiate CIIRP. First, it has to be a financial creditor. That means this particular framework is not applicable to operational creditors. It has to be a financial creditor, number one. Number two, the government will notify that class of financial institutions who would be eligible to initiate CIIRP. Then the eligibility, there has to be a default. There has to be a default of debt. If there is no default, CIIRP cannot be initiated. However, there is no condition that the account should be NPA. There is no condition that the account should be NPA. It can even go to CIIRP immediately on the first default, on the default of 1 day, on the default of one installment, on the default of not repaying the interest on the working capital, on the default of exceeding the withdrawal from the exceeding your drawing power as far as the working capital is concerned. That all is default. In case there is a default, but it is not NPA, yes, the financial creditor can initiate CIIRP. Now, in case the financial creditor thinks that the CIIRP may be initiated, then Section 58 capital B says that there are following steps or actions which are supposed to be taken by the financial creditor. First of all, the financial creditor will take the list of all the creditors, all the financial creditors. Then that financial creditor will see who all are the eligible financial institutions, who all are the financial creditor. First of all, it should be financial creditor. Second, it should be the notified financial institutions. Initially, the notified financial institutions may be all banks in India. All banks in India. I don't think the government will do public sector bank or private sector bank. I don't think that. First of all, I think it will be open to all banks in India. Then this is the first step, that the bank will understand the credit profile, the list of creditors, financial creditors, and the category of the financial creditor, and then will take an approval of at least 51% of the total debt. 51% of those financial institutions or financial creditors who have more than 51% of the total debt due to corporate debtor. That is one thing that first of all, in that meeting, a decision will be taken by way of a meeting, and the approval will be taken by the financial creditor. Some rules and some regulations will be notified, how the approval will be taken, how the meetings will take place. That will come. That will be notified by IBPI. Then in the same meeting, the financial creditor will also take a decision whether they would like to take moratorium benefit or not. See, when PPIRP was started, the PPIRP was starting from a resolution plan which was supposed to be submitted by the promoters. The creditors in India thought that in case we initiate PPIRP, that we are also kind of accepting the resolution plan submitted by the company. And also immediately moratorium will start. So they were in fact using this PPIRP as getting the information from the company. And after getting the information, they used to enforce their security interest, maybe under SAFESI law or any other law. And that was what in fact made a reason for failure of PPIRP. Now, in this case, the banks will have an option whether to start moratorium or whether not to start moratorium. So in the same meeting, they will also take a decision whether the moratorium benefit they would like to take or they will not like to take. Then the third, which is the first step, which is this first step that the financial creditor can take, inform the corporate debtor of its intention to initiate CIRP. Intention to initiate CIIRP, that is the first step that actually will come on the public domain. The company will come to know that my financial creditors are now starting CIIRP, and that's the most important step. The financial creditor will give at least 30 days to the corporate debtor, where the corporate debtor can make a representation before the creditors or before the creditor. And the form and the manner of such representation will also be notified by way of regulations. Now, once the corporate debtor has been given an opportunity to represent, he may go to the financial creditor for settlement. He may go to the financial creditors for a kind of restructuring. He may go to the financial creditors for kind of seeking some time and give some commitment to them. That is the first step. It is an opportunity given to the corporate debtor that he can go and talk to the creditors. In case he will not talk, the CIIRP can be started. Now, in case there is a representation, in case any representation is received from the corporate debtor, and then the final decision after the representation is received from the corporate debtor, then another meeting. In that meeting, it will be again put to vote. Now, after the representation, whether we have 51% plus creditors to start CIIRP, whether in some cases, the representation can be so good that it is acceptable. In some cases, the representation can be good for some and it may not be good for others. So therefore, the 51% voting will again be required after the representation is made, after any proposal is made by the promoters, after any kind of restructuring proposal is made by the promoters. Thereafter, again, a voting would be required so that whether that representation is acceptable to all, acceptable to some, or not acceptable to all. So that is a second meeting in which again it will be decided whether to start CIIRP or not. So in case and no representation is made, in case no representation is made by the corporate debtor, then immediately before the expiry of 30 days, immediately after the expiry of 30 days, the insolvency professional would be appointed as RP, provided there are no disciplinary proceedings are pending before against that RP. Of course, how the RP would be appointed, rules would be made, and that rules are still awaited. In the same time, while we are communicating, while appointing the RP in the same letter, in the same form, whatever rules will come, the RP will also be directed whether to start moratorium or not. Whether the RP will make an application before NCLT to start moratorium or not, that will be the direction given in that communication while appointing an IP as RP. Now, if the financial institution, if the financial creditor is unable to initiate CIRP within 30 days from the date of representation, within 30 days, in case the CIIRP is not started, the entire process of intimating the corporate debtor regarding initiating CIRP and also taking the representation will start again. So 30 days time which is given to the CD to make a representation. Within the next 30 days, either the representation has to be rejected or accepted, and either the CIIRP has to be initiated or not. In case it is not initiated within the next 30 days, then the entire process of intimation, entire process of representation, and that has to be start again. So that is where the main power lies. With the financial creditor, this has almost become surfacey. In surfacey, the security interest can be invoked, it can be taken, it can be realized without going to any court. Similarly, the CIIRP can be started, can be initiated without going to any court, without going to NCLT. The only thing that they have to take, the creditors have to take a decision regarding to initiate CIIRP, to get the moratorium or not, and to appoint the RP. So all this is now given to the creditors, not to the NCLT. NCLT will come later. I will just let you know. So now, once the RP is appointed, his immediate job is to prepare a report. I will come to that. And in case, so this is where the most important part of the CIIRP is lying, that a financial creditor can initiate insolvency. A financial creditor can appoint RP. A financial creditor can decide about moratorium. And 51% voting is required for all this. Financial creditor can can accept a representation. Financial creditor can reject a representation. If 51% of the creditors, based on the total debt, based on the eligibility of the creditors, if they agree, the insolvency can start immediately. So that means, what is the total period? 30 plus 30. 30 days notice has to be given, and then representation and response to representation, and then initiation. So within 60 days, maximum within 60 days, insolvency can be started. So basically, the feedback was that in case of insolvency, in case of CIRP, the promoters are getting too much of time to somehow circumvent the CIRP, to divert some of the businesses, to divert some of the resources. So that time is now reduced to 60 days. Within 60 days, it actually can be immediately debtors in possession. They would still be in control, but it would be under the control of RP. It will be under the control of Committee of Creditors. So this is, now the rules will actually, the government will make rules for the conditions and appointment of RP. And also the class of creditors would be notified who would have this power. The regulation would also be made for taking 51% approval, the regulations for having meetings, the regulations for how to pass a resolution, the regulations regarding representation, the form and the manner of representation, everything will be provided in the regulations. And whenever the central government is also prescribing something, so that actually will be notified, or that may be even prescribed in the rules. Now, let us understand what has been done so far. We have taken the 51% approval. 51% approval has been taken. 51% approval has been taken, and even representation has been taken. The representation has also rejected. The financial creditors has not accepted the representation. There is no one-time settlement. There is no restructuring. There is no effective proposal from the promoters. So therefore, the financial creditors will appoint insolvency professional. So the insolvency professional, when he gets this communication, immediately he will prepare a compliance report. In that compliance report, it is the duty of the insolvency professional, once he is appointed as the RP, he will prepare a compliance report. In that compliance report, he will see whether these financial creditors who have participated in the process, are they eligible financial institutions, number one. Number two, what kind of debt they have due from the corporate debtor, whether that debt is within that limit of income, asset, amount of debt, or any other conditions. This is the duty of the RP to see whether the all compliances has been met by the financial institutions, financial creditor or not. Now let us understand what are the compliances that the RP will verify. Number one, whether this company, whether this corporate debtor comes under the eligible corporate debtors with regard to asset, income, or a combination. With regard to the financial creditors, whether the class of creditors and the amount of debt, any other condition which may be prescribed by way of rules or by way of regulations later. This is the thing, first thing that the RP will see. And the second thing the RP will see, whether all these meetings where 51% people have voted, that all those meetings have taken place as per the regulations or not. Whether all those minutes have been prepared or not. Whether the voting has been done appropriately or not. So all this is, once he see all this, and then he will have to see whether there is a default or not. Once he see all this, then immediately he will make a public announcement for initiating CIIRP. And the date of public announcement will be the date of commencement of CIIRP. Date of public announcement by the RP will be the date of commencement of CIIRP. Now, so far, what we have seen, NCLT has not come in picture. IBBI has not come in picture. It is only the financial creditors and the RP, and the insolvency started. Now coming to the immediately, once this compliance report is prepared, now this is the first time that the RP will submit that compliance report to NCLT and also to IBBI within the prescribed period and in the form and manner which will be notified by IBBI. So this is the commencement of CIIRP without going to NCLT, without going to any other court, simply financial creditors, eligible financial institutions, and eligible corporate debtor. So very important, till now, I think we have seen how easy it would be. It is only a consensus. It is like a SARFAESI law. It is like the process of giving intimation to corporate debtor, the process of taking representation, the process of attending to that representation, the process of meeting, and all this will happen within a period of 60 days. And within 60 days, the CIIRP can be initiated. Now, once this public announcement is done by the RP, there is a different kind of bar on filing applications during CIIRP. So what are those bars? Number one, during CIIRP, the application under section 7, 9, or 10 cannot be submitted, cannot be pursued. And then no application under section 54C for regarding prepackaged also cannot be entertained. Now the key definition that we can see, key definition is the CIIRP commencement date is considered as the date of public announcement. That is the date of commencement of CIIRP. And the second thing is the CIIRP period. CIIRP period is that from the date of public announcement to the date of public announcement to 1 under section 58H, there is a provision for converting CIIRP to CIRP. So that in case it gets converted, that means the CIIRP period is over. Second option, in case the CIIRP is withdrawn with 90% voting, that is also end of the CIIRP period. And in case the resolution plan is approved, or rejected, then also it is the end of the CIIRP period. However, the company will not come out if it is rejected. Company will go to CIRP in case the resolution plan is rejected. So so these are the bars on various applications. Now, let us understand, once the CIIRP is initiated, what are the rights of the corporate debtor? What are the rights of the corporate debtor? The first right is to object. The first right is to object to the commencement of the CIIRP. So the corporate debtor will make an application to NCLT that this CIIRP has not been initiated properly, and this is the problem. Then this has to be done within 30 days from the commencement date. Within 30 days from the commencement date, and then again the form and the regulations and the rules will be notified. So we are waiting for all this, and then the fee, what kind of fee he will pay, that also has to be notified. So that is the first thing that the corporate debtor will make. They make an application to NCLT. Now, an application has gone to NCLT objecting to CIIRP. In the meantime, the RP is working. RP is working, and this period of 150 days is already started. Now, the application has been made by the corporate debtor objecting to the commencement. Now, in case the NCLT see that there is no default, then NCLT, in case there is no default, then the NCLT definitely will see there is no default. It has like one that there is no default. So in that case, the NCLT will pass an order that this initiation is void ab initio. Initiation is void ab initio. The second scenario is that the default has not occurred, and the default has not occurred, and is satisfied that even the CIIRP process has not been initiated properly. CIIRP process has not been initiated. It has not been initiated properly. So then this is a scenario. Then like it will actually be saying the one, it is void ab initio, and second, this decision also has to be taken by NCLT within 30 days from the date of making application. And if no order is passed within 30 days, then it has to be, order has to be, like there has to be reason which is recorded in writing. Now, the second scenario would be that the default has occurred. Default has occurred. NCLT is satisfied that the default has occurred, but the CIIRP process has not been conducted properly. Then the order will be passed within 30 days to start CIRP. Then order will be passed within 30 days to start CIRP, and it will not be something that is going back to the promoters and no action. So default has not occurred. It is void ab initio. Default has occurred, but CIIRP process has not been conducted properly. Representation has not been taken. Representation has not been accepted. Timely actions have not been taken. So therefore, the CIRP will start. CIRP, not the CIIRP. Now let us understand that there may be a possibility that the financial institution, financial creditor has taken a hurried decision immediately after the default and appoints an RP, maybe with some lacuna, maybe with some kind of juggling with the facts. But still, CIIRP has started and it will be converted into CIRP. So that also would be acting as a kind of faster commencement of CIIRP or CIRP. That is also one of the effect of this. Now, the period of CIIRP is defined as 150 days. Unlike CIRP, it is 150 days. In CIRP, it is 180 days. 150 days is the period, and it actually can be extended once with 66% of the voting of the CIRP for COC, and then application will be made by the RP to extend by another 45 days. So the total period will be 150 plus 45, 195 days, and not more than one such application can be submitted to NCLT, although this provision was earlier also there, but natural justice, in fact, had prevailed, and multiple extensions have been sought, multiple extensions have been given in the past. So we actually can see, C question is, let us understand the consequences of no resolution plan approved within the CIIRP period if within 150 days plus extended 45 days, if no resolution plan is approved. If no resolution plan is approved, then NCLT will pass an order under Section 58H to convert CIIRP to CIRP. Convert CIIRP to CIRP, and in case after that, even in case CIRP is also, but the only issue is that one thing is very important, that initiating CIIRP will never lead to liquidity. It will never lead to liquidating the company. It will never lead to liquidation. It will only lead to either one, withdrawal or conversion of CIRP, conversion to CIRP. Otherwise, the liquidation will not come. Subsequently, on failure of CIRP, then liquidation can start, but not because of this. Coming to the powers and the duties of the RP during CIIRP, I will not take much time. I will simply say that all the duties that we have seen, under Section 58E, which is a special section proposed in the amendment bill. Then we also have seen Section 18 of the code, which is already there, and clause A to C is applicable to this framework also. And then we have seen Section 25, subsection 2. However, the clause A, B, C, D are not applicable. All other clauses are applicable. We will actually see, and we will explain what kind of clauses are not applicable. So that is very important part of it. We now can see the Section 58E, what it says, to call for the claims, to prepare information memorandum, to prepare a report, which I said compliance report, to prepare a report on the resolution plan, whether the resolution plan is compliant under Section 29A and also 30. File also the reports and documents to IBBI and to NCLT and perform as per the functions. Now coming to Section 18, everyone knows that what is the duty and what are the obligations of RP under Section 18, subclause 1 to C. All those clauses are applicable here also. But what is important is Section 25, subsection 2, where the clause A says to take immediate custody and control of all the assets of the corporate debtor, including the business records of the corporate debtor. This is not applicable to CIIRP. So therefore, RP is not supposed to take immediate control and custody of all assets and records. So this is what will remain in the possession of debtors. So therefore, here we start the regime as debtor in possession. Then secondly, not to represent and act on behalf of the corporate debtor with third parties, exercise rights for the benefit of the corporate debtor in judicial, quasi-judicial and arbitration proceedings, not applicable. The company will continue to represent and act on behalf of the corporate debtor. The board of directors will continue to act and represent the company for all kind of judicial, quasi-judicial and arbitration proceedings. Third, not to raise interim finance subject to the approval of COC. That interim finance is also not supposed to be raised by the RP. That power doesn't have, the RP doesn't have that power. Then to appoint accountant, legal and other professional, that power is also not there. So basically, these four powers are not there. That means there are obligations and duties on the corporate debtor, that I will come. But the RP is not supposed to take the control and custody of the business, control and custody of the asset. He is not responsible for keeping the company as a going concern. He is not responsible for representing the company before various forums. He is not responsible for raising interim finance, and he is also not responsible for appointing an accountant, legal, or other professionals. However, he will maintain the updated list of claims, and he will convene a committee of creditors meetings. So these are all various duties which are provided in Section 25, and also the duties of under Section 54F. See, when this PPIRP was inserted in the law, there were some powers and duties which were assigned to the RP. And those duties were basically access the books of accounts, records, information available with the corporate debtor, access the electronic records of the CD from an information utility, access the books of accounts and records of the relevant document from the government authorities, attend meetings of the members, meeting of the board of directors, appoint accountant. All this was basically required where some regulations are required. But then Section 54F was inserted when PPIRP was inserted in the IBC. So those powers and duties are also applicable. And then Section 54F also had some powers to collect information, the business operations. All this was information, but no control. Basically, he would not have the control of signing a check. He will not have the control of taking a decision. He will only have he will only have the right of information. He will only have the right to block a resolution. He will only have the right to prevent some wrong doings. So those are the powers. And then we also can see. So all these are the powers. He will not be maintaining the bank account, but the financial institutions and the banks will have to provide information to the RP for all the banking transactions. Now, this amendment bill has also made a good amendment regarding the seeking information, seeking cooperation from extended persons. Now, the extended persons are like any person who or has been a personnel of the corporate debtor, any person who is or has been the promoter of the corporate debtor, any person who is or has been associated with the management of the corporate debtor, any person who is or has been engaged in a contract for service with the corporate debtor. So that extended cooperation, extended persons would also be applicable here. So the RP would be able to take information from all of them, and all they are supposed to provide information. RP will have the power to file Section 19, subsection 2 application before NCLT, seeking cooperation from them. And NCLT can also pass order under Section 19, subsection 3, directing them to give an information. Now, this is what is the debtor in control. I'm saying the management continuity is the debtor in control. That's a process. Debtor in control, debtor in possession, DIP. Earlier, we actually have a CIP, creditors in control or creditor in possession. Now we have DIC. So this is under Section 58F. Now, the management of the affairs of the corporate debtor shall continue to vest with the board of directors. This is what is provided in Section 58F. Management will continue with the board of directors. The provisions of Section 54H shall apply to this chapter. Now, Section 54H is to protect and preserve the value of the property. That is the duty of the promoters, the board of directors. To keep the company as a going concern will be the duty of the corporate debtor. Shall exercise on the discharge of. So the management, the board of directors, they also have right, whatever contractual right they are continuing with the company, they will continue with the company. They will continue to draw those salaries. They would continue to draw all those perquisites during this period. All those, they shall exercise and discharge their contractual or statutory rights and obligations in relation to the corporate debtor. So they would continue to take salary, they would continue to take perquisites, they would continue to use the assets which are given to them for their personal use. That will continue. However, everything will be under the monitoring of the RP. Now, the resolution professionals shall attend to all the meetings of the members and the board of directors and the committee of creditors, committees of the directors also, or partners. RP shall have the right. RP shall have the right to reject any resolution passed in these meetings, subject to such conditions as may be, or in a manner as may be specified. Regulations are awaited. if RP rejects a resolution, it shall not be approved. If RP rejects a resolution, it will not be approved. And if RP rejects a resolution, it shall not be approved. That's what is important. Obligations, again, like I've said, that the promoters and the personals of the corporate debtor, they would provide information. And they, for making information memorandum, they actually, without prejudice to Section 77A, be liable to pay compensation to every person who has sustained such loss or damage. So then, this is again like a effective Section 77A, or like this is an obligation, and the penalty can even go from 1 lakh to 1 crore of rupees, and even the imprisonment also, it can actually go up to 3 years, not less than 3 years, but it may go to 5 years. So any such kind of misleading information, false information, or even where any person like the creditors in fact will be a person who actually will face or have some damage or loss in case the assets of the company are taken away. So in case that is done, that also would be considered as a violation, and prosecution under Section 77A can be launched, and there can be a imprisonment, which actually may be between 3 to 5 years, and there can be a penalty also between 1 lakh to 1 crore or both. So this is again like to prevent a debtor in possession situation, and to prevent misuse of debtor in possession and debtor in control situation. Now coming to the moratorium part of it. Now, since the creditors, in case the creditors decide in a meeting, as we've discussed in the very beginning of this episode, if they decide, they can even apply for moratorium. So in case they apply, they will direct accordingly to RP that they have taken a decision to apply for moratorium. Once the public announcement is made, immediately after that, the RP will make an application to NCLT for moratorium under Section 14. COC has already taken a decision, then only the RP will get the directions and instructions. Now, let us see here, when the RP makes an application to NCLT saying that the moratorium may be started, moratorium will immediately commence on the filing of the IA and will continue till the continuation of the CIIRP. There is no need for even order. If the application is filed, that will start moratorium. NCLT may confirm the moratorium if satisfied that it is required for the efficient conduct of the CIRP, and NCLT also may reject the moratorium, because the NCLT may say that the moratorium in this case is not required. However, NCLT can say yes, NCLT can say no also, but as far as the creditors are concerned, as far as the corporate debtor is concerned, the moratorium will start from the date of submission of application by RP to NCLT. Now, in case it is moratorium is rejected, then the RP will make a public announcement. In that public announcement, the RP will say that we have filed an application for moratorium, but it has been rejected. So that is the obligation of the RP on moratorium. Now we come to Section 58H, which is the circumstances under which the CIIRP is converted into CIRP. IIRP is converted to CIRP by NCLT. That is, the first scenario is that the NCLT does not receive a resolution plan for approval within a period stipulated, that is 150 days plus 45 days. Then the CIIRP will be converted to CIRP. Second, in case the NCLT thinks that the under Section 19(2) application that the corporate debtor or the personals have not cooperated with the RP and have failed to assist the RP, have failed to provide the information as required under the law to RP, then also they can pass an order converting to CIRP. Third, in case a resolution plan is submitted but it is rejected, maybe because of various non-compliances, maybe because of some mandatory contents under Section 38, and some of the mandatory content maybe even come under the regulations, as we have Regulation 38 for CIRP regulations, Then NCLT shall pass an order to convert the CIIRP to CIRP, and all provisions of CIRP would be applicable. The NCLT will also decide the stage from which CIRP shall commence, and that stage can be one, starting from the fresh EOI, or even starting from the process which is already conducted. So that is where the stage has to be started. Stage has also been, so stage is also to be decided by the NCLT, and appoint the same person who was appointed as the RP during CIIRP as RP during CIRP. So anyone who is appointed as RP for CIIRP will be appointed as RP for CIRP also, and declare moratorium, and declare that all the cost, whatever has actually been incurred during CIIRP, would actually be the cost during CIRP, and it will be recovered during CIRP. Now, when this is converted, when the CIIRP is converted to CIRP by NCLT, then the vote, like the COC also can do that. With the decision of the COC, 66% voting is required. If during 150 days or 45 days, if the COC thinks that this is not getting resolved, the promoters and the personals of the CD are not cooperating, even they can pass a resolution with 66% to convert CIIRP to CIRP, and the RP will make an application to NCLT again for converting to CIRP. NCLT will pass an order and will declare again as per the effect. Now, when this conversion is done, conversion to CIRP is done, when the NCLT passes an order to convert CIIRP to CIRP, under Chapter 2, the proceeding initiated for the avoidance transaction or fraudulent or wrongful trading transactions shall continue. Such an order shall be deemed to be an order of admission of Section 7 application, and the financial creditor who initiated the CIRP under Section 58B shall be considered the applicant for the purpose. And for the purposes of Section 43, 46, and 50, the references to initiate, and of course, that is a look-back period. Look-back period will also accordingly change. So there are provisions for withdrawal of CIIRP also. But however, 90% voting is required. 90% voting is required for withdrawal, and that is where the NCLT may allow the withdrawal of public announcement made under subsection 4 of Section 58B with 90% of the voting of the COC. Regulations are still awaited, like in which form it will be submitted, which form the 99% will be. Application will be made by the RP. Public announcement cannot be withdrawn before the constitution of the COC. And the public announcement cannot be withdrawn after the first expression of interest for submission of a resolution plan has been issued by the RP. NCLT shall pass this order within 14 days from the date of receipt of the application, and in case no order is passed within 14 days, NCLT record reasons for that. This is what is the provision under Section 58I regarding the withdrawal of CIIRP. It is called withdrawal of public announcement. It is called withdrawal of public announcement. The public announcement is the document which actually starts the insolvency under CIIRP. Coming to Section 58J, which is important, the COC, that is the approval of the resolution plan. If the COC approves the resolution plan with a vote of not less than 66%, RP will submit a resolution plan to NCLT along with the RP's report, which is like the report which we already have in CIRP, similar report. RP also to certify that the resolution plan is 29A compliant and also compliant to Section 30. NCLT will pass an order under Section 31, and all the provisions of Section 31 would be applicable. For example, in case of any deficiency in the resolution plan, the NCLT will give notice to the COC to cure the defect. Also, 30 days period is like passing the order, that is also mentioned in Section 30 now. Like various licenses to continue, not to revoke, not to suspend, not to terminate. Clean slate position, which is now proposed in the code, which earlier it was because of the judicial pronouncements, and no proceedings to be initiated even after the resolution plan. All that is applicable. All that is applicable once a resolution plan is approved. There are various other sections which are applicable to CIIRP, like Section 21 and Section 24. So these sections are descriptions of COC constitution, their meetings, and their rights. It will continue as we have already in the code. Then Section 25A, Section 26, Section 27, Section 28. These are the duties of the authorized representative of class of creditors, and also POFE applications. Also POFE applications not to affect CIIRP. Then it is regarding the replacement of RP. RP can also be replaced. Then then we have the provisions of Section 28A, 29, 32, 32A, Section 43 to 51, all the provisions of Chapter 6, all the provisions of Chapter 7, modifications, conditions. So all this, like the COC approval, 66% collective bidding of PG, that is also applicable now. Collective bidding of the personal guarantor's asset or corporate guarantor's asset, that is also possible in CIIRP. And then information memorandum, and then appeal provisions are also applicable. Protection from investigation agencies like Section 31, 32A is also applicable. All the avoidance transaction rules are also applicable to CIIRP. Section 63, 64, 65, 66, all penalties and offenses, all are applicable in the process. All are applicable. So I would, this is where we end now, and we actually we can take some of the questions. I can see some questions are there. So in fact, I can start with the first question. The question is, so now in this process of CIIRP, no need to first commit a default by CD over 1 crore and Section 7 application to be filed for the formation of the COC post admission of the application. Will this process be revoked? No. See, as far as the Section 7 is concerned, that is continuing. As far as Section 9 is concerned, that is continuing. So there is no change. Rather, this is a new framework within the same code where the income, asset, eligibility, everything will be defined. It will come in the regulations and rules. But the Section 7, Section 9 applications of that 1 crore more, everything is continuing. That is, everything is applicable. Now, see, Venkata Rao is saying if no resolution plan is received, whether conversion of CIIRP to normal CIRP is automatic or no. Passing of order is required in case no resolution plan is received. Then either COC will apply for converting to CIRP, or NCLT will pass an order converting to CIRP. But the first, it has already been established that the default has occurred. Then Mr. Kedia is saying if RP finds the immovable property in the name of CD which was not disclosed by the suspended board and was recorded in books at a stage when resolution plan approved by the COC pending AA approval, IM does not contain such asset, immediately the resolution professional will bring this information to NCLT. NCLT will take action under Section 77A, which is a prosecution of the promoters or all those people who have made this kind of error or offense. So immediately, and that process, which is the CIIRP, will be converted into CIRP, and the entire control and custody will be taken by the RP. Entire control and custody will be taken by the RP. That's what I said. That's then Mr. Venkata Rao says, asking question, presently average time taken for CIRP is 497 days. In cases where CIRP fails for any reason, whether the process of CIRP is required to be commenced from zero level? Yes, this is a good question. As I said, the NCLT will decide at what stage the CIRP will start. Means the RP under CIRP will be allowed to conduct a fresh EOI, or will only continue with the existing resolution plans in hand, or will actually invite for the... So the stage at which the CIRP will start, that will depend upon various scenarios, and the NCLT will decide about this. As far as the overall delay is concerned, I think this amendment bill is considering it well. one, that the capacity of the NCLT may be increased by way of amendment in the Companies Act. Also, there are various litigation which actually will be controlled because of amendments proposed in the amendment bill. So therefore, we feel that the time taken for CIRP will be much reduced. Mehraj Kumar is asking, the CIIRP is converted in CIRP, then public announcement is required to be published once again. Yes. Like as I said, the NCLT will decide whether a fresh public announcement would be required or whether the same list of creditors, same company of COC would continue. And only thing that the CIRP will start from the time when the IM can be modified, and immediately the public announcement for inviting resolution plans can be started. That is where the NCLT will most probably say that the CIRP will start. Whether on conversion from CIIRP to CIRP rupees 1 crore threshold limit is to be seen. I think when the rules will come, even CIIRP would not be possible to start if the default is for less than 1 crore. So that is not a concern. Less than 1 crore default would not be considered as a default for the purpose of IBC. So that will be the first condition of CIIRP also. So that will not be a condition that in case there is a person who doesn't have 1 crore default, and in case we start the CIIRP, then automatically CIRP can be started, because for CIIRP also, when you will see the notification of assets income that will actually have between 1 crore or between 2 crore to something like 500 crores. So therefore, that situation will never come. So since there is no more questions, I can say that thank you very much. It is the time also has I think it is really a very important subject for all of us, and we all can focus on this kind of practice. Thank you very much. This is our way of learning. Thank you.